Lesson: The Constitution, Privacy Rights, and Governmental Structure. The Constitution of the United States serves as a foundational blueprint for the nation's legal and governmental structure, delineating the powers and responsibilities of the government while also safeguarding individual rights. Among these protected rights, the concept of privacy holds a significant place, albeit not explicitly mentioned in the text of the Constitution. The interplay between privacy rights and governmental structure is a critical area of study for privacy professionals, particularly in the evolving landscape of digital information and technology. Understanding this interplay involves examining the Constitution's provisions, judicial interpretations, and the practical frameworks used to address privacy issues in the U.S. The Constitution establishes a system of checks and balances among the three branches of government: executive, legislative, and judicial, each with distinct roles that affect privacy rights. The legislative branch, through statutes such as the Privacy Act of 1974, directly addresses privacy concerns by regulating government data collection and use. This act requires government agencies to maintain records with accuracy and fairness, providing individuals with the right to access and amend their records. Privacy professionals can leverage tools such as privacy impact assessments to ensure compliance with these regulations. PIAs help evaluate the privacy implications of new or existing systems and processes, allowing organizations to identify and mitigate risks proactively. The judicial branch plays a crucial role in interpreting the Constitution and statutes, often shaping the landscape of privacy rights through landmark cases. For instance, the Supreme Court case Katz v. United States expanded the understanding of the Fourth Amendment, which protects against unreasonable searches and seizures, to include the protection of private conversations against electronic surveillance. This decision underscored the principle that privacy is not confined to physical spaces, but extends to areas where individuals have a reasonable expectation of privacy. Privacy professionals should be aware of such judicial precedents as they develop privacy policies and frameworks that align with legal standards. The executive branch, through agencies like the Federal Trade Commission, enforces privacy laws and guidelines. The FTC's role is crucial in regulating privacy practices in the commercial sector, particularly with regard to consumer data protection. The agency's enforcement actions often set significant precedents and influence industry standards. Privacy professionals can utilize frameworks such as the FTC's Fair Information Practice Principles to guide their data privacy strategies. These principles, such as notice, choice, access, and security, provide a comprehensive approach to managing personal information, ensuring transparency and accountability in data handling practices. Beyond the constitutional framework, privacy rights in the U.S. are also shaped by sector-specific regulations, such as the Health Insurance Portability and Accountability Act for healthcare information and the Gramm-Leach-Bliley Act for financial data. These laws impose specific obligations on organizations to protect sensitive information, requiring the implementation of administrative, technical, and physical safeguards. Privacy professionals must be adept at navigating these regulatory environments, employing risk assessment tools and compliance checklists to ensure adherence to legal requirements. For example, conducting regular audits and training sessions can help organizations maintain robust privacy programs and mitigate potential breaches. In the context of digital privacy, the rapid advancement of technology poses unique challenges and opportunities. The rise of big data analytics, artificial intelligence, and the Internet of Things has transformed how personal information is collected, processed, and shared. Privacy professionals must adopt a forward-looking approach, utilizing privacy by design principles to embed privacy considerations into the development of new technologies and systems. This proactive strategy involves integrating privacy controls at the outset of product development, ensuring that privacy is a fundamental component rather than an afterthought. A practical example of privacy by design can be seen in the implementation of data minimization techniques, which limit the collection and retention of personal information to what is strictly necessary for specific purposes. By adopting this approach, Organizations can reduce the risk of data breaches and enhance consumer trust. Moreover, the use of encryption and anonymization tools can further protect sensitive data, ensuring that even if information is intercepted, it remains unintelligible to unauthorized parties. The global nature of digital information also necessitates an understanding of international privacy standards and frameworks. The European Union's General Data Protection Regulation has set a high bar for data protection, influencing privacy practices worldwide. While the U.S. does not have a comprehensive federal privacy law akin to the GDPR, privacy professionals must be cognizant of its principles, especially when dealing with cross-border data transfers. Implementing mechanisms such as data transfer agreements and adopting GDPR-aligned policies can help organizations navigate the complexities of international data protection. In conclusion, the intersection of the Constitution, privacy rights, and governmental structure presents a multifaceted landscape for privacy professionals. By understanding the constitutional provisions, judicial interpretations, and statutory regulations, professionals can develop effective privacy strategies that align with legal standards and protect individual rights. Practical tools such as privacy impact assessments, the FTC's FIP piece, and privacy by design principles provide actionable insights for addressing real-world challenges. As technology continues to evolve, privacy professionals must remain vigilant and adaptable, ensuring that privacy considerations are integrated into every aspect of data management and organizational processes. This comprehensive approach not only enhances proficiency in privacy law, but also fosters a culture of trust and accountability in the digital age.